Hello, my name is Sheana Kleist. I'm an attorney with Northwest Justice Project, and I am here to discuss with you how to access special education services for your child. The agenda for this presentation: first, we'll discuss an introduction to special education. We will then discuss the referral process for special education services, and we will briefly discuss the evaluation, eligibility requirements, and then talk next steps. So what is special education? Special education means specially designed instruction at no cost to the parents or guardians to meet the unique needs of a child with a disability. Special education differs from regular, or sometimes referred to as general education, in two main ways. First, there is different instructional methods used, and second, additional specialists and services are involved. This can involve speech therapists, occupational therapists, specialized teachers. It depends on the unique needs of your student as to what instructional methods are used and which specialists and services are involved. Special education is governed by numerous laws and procedures designed to provide your child with free, appropriate public education, often referred to as FAPE. Every student receiving special education services is entitled to FAPE, and the key word in FAPE is appropriate. Appropriate means that this education must be designed to meet the individual educational needs of your child. What is appropriate for one student may not be appropriate for another student. Special education is governed by both federal and state laws. At the federal level, you'll hear about the Individuals with Disabilities Education Act, the IDEA. You may also hear mentioned Section 504 of the Rehabilitation Act, a federal civil rights law, or the ADA, Americans with Disabilities Act. At the state law, you'll often hear reference to what are called the WACs, the Washington Administrative Code. Now let's discuss how you access special education services for your child. The first step is a referral for an evaluation. When your child is struggling in school and has a known or suspected disability, a referral is a request to the school district to evaluate your child to determine eligibility for special education. So who can make a referral? In Washington, the WAC, or the Washington Administrative Code, says that a parent guardian can make a referral, the school district can make a referral, another public agency, or other persons knowledgeable about the child. This may be a pediatrician, doctor, or other service provider. Let's discuss school district referrals. School districts under the IDEA have a child find responsibility. This means that school districts have an affirmative duty to locate and identify all students who reside in the district who may need special education services. This includes students not enrolled in schools in the district, including children in hospitals and long-term stays, private schools, homeschooled, or other situations. These children reside within the district and are included in the district's child find responsibilities. The child find process can result in a school district staff referring a student to the district for evaluation. If a child is identified as a student who may need special education services, the district evaluates the child to determine eligibility for special education in all areas of suspected disability. Importantly, to conduct an evaluation, districts must provide notice to parents or guardians and obtain written consent before the evaluation can take place. So how can a parent or guardian make a referral? First, it's important to do it in writing. You should date it and make a copy for your records. When you make the referral, you can request that your child be evaluated for both IDEA eligibility to receive an IEP, or for 504 eligibility to receive a 504 plan. When you're writing this referral, you should include information about what is going on with your child. Be specific. You can describe all areas of concerns, such as my child is struggling with reading, but also has some behavior issues. Use examples from your own observations to explain why you think your child may have a disability. You can include documentation if you have it. For example, medical records or a letter from a doctor or other service provider. Once you have the referral written, provide it to somebody who has the authority to act on it. You can send the referral to your school principal or the district's special education director. Once a written referral is submitted to the school district has 25 school days to respond to the request. When deciding to evaluate, the district must consider any existing medical and educational records in the school file and any records provided by the parent or guardian. Once they make a decision on whether or not to evaluate your child, they will have 35 school days to complete an evaluation. The 35 school day timeline starts ticking once you provide the district written consent to conduct an evaluation. Parents and guardians can agree to waive this 35-day timeline as long as the district documents this waiver in writing. For example, the district may need a little more time to attain all the information to fully evaluate your child. Once the evaluation is complete, the district has 30 calendar days to write and implement an individualized education program, an IEP, for an eligible student. When the IEP is complete, services begin ASAP with signed parent or guardian consent. Now, you may have noticed that I discussed school days and calendar days in this timeline. School days are all days of the week when children are in attendance. This means when there's a school holiday or a school break or a weather closure, those days do not count on the timeline. This distinction is important because when the district has 30 calendar days to write and implement that IEP, that timeline keeps running even if summer break starts or any other holiday happens. So what happens when a referral decision is made? Once a district has made a decision about whether to evaluate, the district must send written notice, referred to as a prior written notice or PWN, of its decision to the child's parent or guardian. The PWN must include notice of due process rights, and if the district decides not to evaluate your child, you can challenge this decision. Now let's discuss the evaluation process. The initial evaluation process involves 3 main steps. The first one is administering the appropriate tests and assessment to evaluate your child. The second is completion of the evaluation report. And the third is an evaluation group meeting to discuss the results and determine eligibility for special education services. As to that group meeting, the parent or guardian should be included. The purpose of the initial evaluation is to answer 3 main questions in each area of learning that is being evaluated. First, does the student have a disability? Second, does the disability adversely impact education? Third, does the student need specially designed instruction? If the evaluation answers yes to all 3 of these questions, then your child is eligible for special education services. For instance, question 1, does my child have a disability? Yes, the evaluation found my child has dyslexia. Number 2, does the disability adversely impact education? Yes, this dyslexia is making it hard for my child to learn how to read. 3, does the student need specially designed instruction? Yes, my student needs alternative methods of instruction to help with their dyslexia and learning to read. Answering yes to all 3 of those questions means your child is likely eligible for special education services. In contrast, does my child have a disability? Yes, my child has ADHD. Does the disability adversely impact education? Yes, because of my child's ADHD, they have difficulty in getting their homework in on time or completing in-class assignments on time. Number 3, does the student need specially designed instruction? Perhaps the evaluation found no, that providing your child more time to complete homework or in-class assignments would be sufficient, and they do not need that specially designed instruction or alternative instruction methods. In this case, a 504 plan might be more appropriate for your child. So you may be wondering who will do the evaluation and testing. Qualified professionals in the area of suspected disability will be conducting your child's tests and assessments for the evaluation. This could include a school psychologist, a psychiatrist, a physical therapist, a speech therapist, or a medical doctor, or other professionals that are needed to identify and assess your child's unique needs. So what is being evaluated? Examples of areas that are commonly evaluated can include physical and mental health, vision, hearing, social emotional learning, which can highlight disabilities related to behavior, social interactions, mental health, or emotional regulation, general intelligence, which can include testing IQ. These tests provide important data about a student's strengths and weaknesses that could be important when developing the IEP. Academic performance. Testing in specific academic areas can seek information about whether the student may have a specific learning disability, such as dyslexia, communication, speech, and language, motor abilities and functional skills, autism spectrum, or adaptive skills, which can assess how a student transitions from class to class or organizes their materials. Those areas of evaluation are associated with a number of eligibility categories. These eligibility categories are intended to identify the needs of your child. These are broad categories. A child could qualify for an IEP under multiple categories. The district must address all areas of need and design instruction to meet all of those needs. These categories include intellectual disability, hearing impairment, speech or language impairment, visual impairment, emotional behavioral disability, such as anxiety, depression, post-traumatic stress, or other disorders, specific learning disability, which can include issues related to dyslexia or other learning deficits, orthopedic impairment, autism, traumatic brain injury, other health impairment, which can include ADHD, other categories, and developmental delay for ages 3 to 8. So once the evaluation is complete, what happens if your child is found eligible? As I stated, the school district has 30 calendar days to write and implement an IEP for your child. This means the school district will schedule and hold an initial IEP team meeting, and they must include the parent or guardian. The school district must also obtain parent or guardian written consent to initiate special education services. The school district will complete a reevaluation at least every 3 years to confirm your child's continued eligibility. However, you can request an evaluation earlier than the 3 years if your child's needs change and the IEP team needs more information to revise the IEP. Now let's discuss what happens if your child is found ineligible. First, you may want to consider requesting an IEE, an independent educational evaluation at school district expense. An IEE is an evaluation conducted by a qualified person who is not an employee of the district. The school district must give parents and guardians information about where an IEE can be obtained, and the parents and guardians get to choose who does the IEE. When a parent or guardian requests an IEE, the school district has 15 calendar days to request a due process hearing if it opposes the IEE request. If a hearing is held and the hearing officer determines the district's initial evaluation is adequate, the parent and guardian can still obtain an IEE, but the district does not have to pay for it. If the parent or guardian goes forward with the IEE, the district must still consider the IEE results. So what else may happen if your child is found ineligible? You may want to request a 504 plan. A child ineligible for special education services may still be eligible for a 504 plan. 504 plan eligibility is different than IEP eligibility. Eligibility under 504 requires a disability or condition that substantially impairs a major life activity. Learning is a major life activity. A 504 plan includes modifications or accommodations to allow a child with a disability to receive FAPE, free appropriate public education. Unlike an IEP, a 504 plan does not include goals or specially designed instruction. However, both IEPs and 504 plans address the needs of students with disabilities. So what are other options if your child is found ineligible? You can challenge the decision. School districts must notify you of its decision in writing, called a prior written notice. So you can challenge the district's decision. You can request a facilitation, a mediation, or a due process hearing. So you can challenge the decision. You can submit a community complaint to Washington Office of Superintendent of Public Instruction, often referred to as OSPI, or you can submit a complaint to the U.S. Department of Education Office of Civil Rights, often referred to as OCR. In addition to those complaints, you can also challenge the decision via your due process rights. You can request a facilitation, mediation, or due process hearing. I'll briefly discuss what each of those are. First, a facilitation. A facilitated meeting is an option to use a neutral third party, a facilitator, to promote effective communication. A meeting facilitator's role is to guide the meeting process so that all members can participate and provide their input. Importantly, a facilitator is not meant to argue for one side or the other, and they are not an advocate for the parent, guardian, or the student. Use of a meeting facilitator is voluntary, and both the district and the parent guardian must agree. A facilitator is provided at no cost to the parent or guardian. Next, you have an option of requesting a mediation. A mediation is a bit more formal than a facilitation. However, like a facilitation, a mediation is use of a neutral third party to help resolve disagreements and to help the parties reach a mutually acceptable agreement, though an agreement may not be reached at the end of a mediation. Like a facilitator, a mediator is not meant to argue for one side or another, and a mediator is not an advocate for the parent or student. Mediation is a voluntary process. and both the parent and guardian and the district must agree to participate. Mediation cannot be used to delay or deny a parent's right to a due process hearing. Mediation is provided at no cost to the parent or guardian. Unlike a facilitation, mediation negotiations are confidential. The conversations may not be used as evidence in a community complaint, an OCR complaint, a due process hearing, or a court hearing. If an agreement is reached during mediation, however, that agreement is not confidential. Finally, there's due process hearing. A due process hearing is a legal proceeding conducted by an ALJ, an administrative law judge, at the Office of Administrative Hearings, OAH. Both sides can present and question witnesses during the hearing and submit and present evidence. A request for a due process hearing must be made in writing, and there is a time limit. You have 2 years to request a due process hearing. For example, if the district says your child is not eligible for special education services, you have 2 years from receiving that notice to request a due process hearing. Once parents submit a request for a due process hearing, districts must hold a resolution session within 15 days of the request, or 7 days if it's a hearing involving discipline. Parents and guardians can waive the resolution meeting or agree to a mediation instead. If the dispute is not resolved after the resolution meeting, the hearing must be held and a decision issued within 45 calendar days. Once the ALJ issues the decision, either the parents or the school district can appeal the decision to state superior court or federal court. So in summary, the first step to your child receiving special education services is to make a referral for an evaluation. You should make that referral in writing. Strict timelines do apply, and school districts need parental consent before they can move forward with the evaluation. Evaluations must be comprehensive and evaluate all areas of suspected disability. Your child is eligible for special education services if they have a disability that negatively impacts their education and they are in need of specially designed instruction. If ineligible for an IEP, your child may still qualify for a 504 plan with accommodations and modifications. And remember, you have due process rights. You can challenge a school district's decision. Thank you for joining me. I hope you found this presentation useful, and I wish you the best of luck going forward.